Hello and welcome to Regional Counsel, presented to you by the Singapore Academy of Law. My name is Nicole and I am your host for today. Regional Counsel is a series of short video podcasts on legal content catered to in-house counsel who are new to ASEAN regional work. This series is not meant to be a deep dive, but to equip in-house counsel with tips and tricks from experts to navigate the challenges faced when dealing with jurisdictional specific quirks. In today's episode, we will be delving into Indonesia law with an expert, Associate Professor Gary Bell of the National University of Singapore. Hello, Professor Bell. Thank you for joining us today from Canada. We really would like to hear from your perspectives as an arbitrator later on. But first of all, could you just share with us a bit about the Indonesian legal system? I understand there's pluralism between the civil law traditions, Islamic law, and as well adat law. Perhaps you could share with us a little bit about the Indonesian legal system?
Yes. There are basically three legal traditions in place in Indonesia. The oldest one is the adat laws, which should put it in a plural because there are many different adat laws for every region. There's a Javanese adat law, there's a Balinese adat law. Every island has at least, almost every island has one separate adat law. So adat is actually come from Arabic word ada, which means custom. So it's a customary law, basically, of different regions. So that's one source of law. That was the oldest source of law. Then Islam came to Indonesia, to most parts of Indonesia, not everywhere. And Islamic law came with it, although never a very strong. The Indonesian Islam has been founded by Sufis, which were more into spirituality than law, which is strange for Islam because Islam is very much a religion of the law.
Yes,
but anyway, there's a legal tradition anyway there of Islamic legal tradition, and there's a civil law, which is the last to come through the Dutch colonization. But in fact, when the Dutch came, a bit like the English originally in Singapore, they weren't interested in. They were happy to leave the locals do their own stuff, right? As long as they could exploit the resources and become rich out of the land, right? So basically, they said we'll apply civil law only to the Dutch, to the Europeans. You apply your adat law and Islamic law. Now I'm simplifying. It's not as clear-cut as that. Criminal law, of course, they wanted to administer that as well. And eventually the courts that administered Islamic law and that law were Dutch-created courts. So it has eventually been integrated, but this kind of pluralism that was in place under the Dutch was continued after the Dutch left. So there is still some of that law. There's still quite a bit of Islamic law. But in commercial law, the most important is the civil law.
Yes.
Of course, if you do Islamic financing, by choice you choose Islamic law. But the presumption is that pretty much every commercial enterprise, every commercial contract will be governed by the civil code and commercial code.
Understand. Thank you so much for sharing that.
That's generally how it works. I keep mentioning the civil code. It comes from the Dutch and it's in Dutch. To this day, there is no official version of the Indonesian civil code in Indonesian.
I see.
There are translations, none of which are official, and none of which seem to agree on the terminology as well. So it's a bit of a difficulty because the lawyers, the judges don't speak Dutch. Very few of them do. And they have to apply a law. It would be like a civil law person, which is the case in South Africa, for example, who would have to apply Latin text because there's nothing in. So it's very strange, but that's the situation as it is. Now, the last thing I would say about the legal system is that when they wanted to update something that was in the civil code or the commercial code, they didn't want to change it in Dutch, right? So what they did is they took it out of the code, right? So for example, family law, marriage, they adopted a separate law for marriage law. So it's no longer in the code. The land law, which used to be in the code, at least for the land governed by the civil code, now they unified the land law, adat law, and civil law into a special statute, which therefore there's no land law in the civil code anymore.
Okay.
Right?
That's interesting.
So they took part of the codes outside. One of the most important for corporate counsel the company law used to be in the commercial code. They took it out of the commercial code, and now there's a separate company law that is in Indonesian. Still civil law inspired, though. I mean, we're still not in the common law, right?
Yes.
But it's a statute rather than a code.
Okay. Thank you so much for sharing. I mean, it's really given us a good layer of the land in Indonesia, the different types of traditions that apply. And also, can I just check with you, would you be able to share with us some of the sources of law in Indonesia and perhaps the hierarchy of how these sources of law apply?
Yes. Of course, to some extent, the most important law is the Constitution, right, which is at the top of the system. But then the law of the state is really, in a way, in charge of deciding which law applies. Yes. So, for example, Islamic law will apply to the extent that the state has decided it would apply. And essentially, it applies in family law, it applies in divorce, it applies in inheritance and things like that, and only to Muslim. And it can apply in commercial and banking, etc., but by choice, right? And then with respect to Adat law, it's also quite clear the very few areas where it's still relevant. And there's a land law has been said to be inspired from Adat. But the sources of law are different for every system. Even though the state has an administration, it's a bit like Singapore, where you have the administration of Muslim Law Act. It's not telling you what a Muslim law is. It's just telling you how the courts will work and how, right?
Yes.
The Islamic law sources are the Quran, the Sunnah, etc. Now, in civil law, and I'm going to concentrate on that because that's what's most important for counsel, what are the sources of law there? Of course, the civil code. As most people know, the civil law is very much, at first, at least as a main source, a code, a civil code, a commercial code, also the Company Act. So it's statutory based to a large extent. But people are often mistaken in thinking that everything is in a code. It's not. There's a lot of things that are not in a code, and in a well-functioning civil law system, you will find a lot of answers in the jurisprudence, which is how we call case law. They're not technically law in civil law because we don't have stare decisis.
Yes, that's right.
But there are, if many decisions go in the same direction, it becomes kind of the law. I'll give you an example of that. We have no rules in the civil code on offer and acceptance. It only says that the contract is formed by consent. But what does it mean? Offer and acceptance, how long is an offer valid, etc. All of this is found in the doctrine and the jurisprudence. So it's not true that everything's in the code, right? So people have to be aware of that. So jurisprudence is court cases, but there's a problem in Indonesia, and I don't want to be too critical here, but compared to a jurisdiction like France or Holland, we don't have, until recently, a lot of the decisions that are published, right? And on top of that, now we have all the decisions published by the Supreme Court, but they're contradicting themselves, and not a lot of them are commercial-oriented. And there's a bit of a weakness in the court, as my colleagues in Indonesia will tell you voluntarily. There's a lot of corruptions in the courts, so their judgments are not necessarily very reliable. So there's a tendency to not make too much of what the courts are saying, which is sad, because when you go to France, the civil code is published with tons of annotation of referring to referring to this case decided that case decided that author wrote a book on this. So the doctrine is referred to with respect to each article of the code. We don't have a systematic approach like that in Indonesia. So to a larger extent, we have to argue from first principles because we have mainly the code. Sometimes you can refer to and it's not binding, but you can look at other jurisdictions that have exactly the same code, right? Because France, Netherlands, Belgium, many countries in Africa have the same civil code. So decisions there can help us understand how it could be applied, not that it is binding at all, right? So this is kind of the different sources of law that you can have.
Okay, thank you very much for sharing that. Maybe just to summarize what you have said so far, I think I understand that Indonesia is in the civil law tradition. It does have other sources of law, like Adat law and also Islamic law, due to its history. And I understand when the Dutch came, they only applied the civil laws to their people, the Dutch people. But right now, it's a bit of a mix. It's a bit of a hybrid system. Some things have been codified, for example, in land law. Most things, I mean, as you shared, come from jurisprudence. But that itself also has challenges because the courts sometimes have conflicting judgments, as you shared earlier on. And it's not like in a French system where, the civil code has, annotations that are specific to certain cases. And therefore, I think Indonesia is a complicated jurisdiction, I would say, for lawyers who have not encountered, the Indonesian legal system and are trying to navigate the ways around. So thank you very much for sharing that on. I think it gives us a very good overview on the legal system. Could I just pick your brain? Can you just share with us about the legal institutions in Indonesia? You mentioned the courts earlier on. Would you be able to expand more on that for us?
Yes. First of all, I'm going to mention. You might wonder why, but I'm going to mention first the Constitutional Court. Commercial people don't think of constitution. Why, human rights? Why? But in fact, the Indonesian constitution has a provision that provides that natural resources and what comes in the land and the air and everything must be managed by the state. And that's in the Constitution. And it has led to the Supreme Court saying, no, you cannot have foreigners in charge of electricity. It has to be owned by the state. So a lot of investment have become very impossible or insecure, and contracts have been changed because of Constitutional Court decision. Now, unlike in the most common law jurisdiction, constitutional issues are decided by a separate court that is not part of the hierarchy. So not every judge has a power to decide constitutional issues, only that court. So that's a short mention, but lawyers should worry about the constitution in Indonesia. It affects a lot of things.
Okay,
right?
That's very helpful to know.
It affects labor law. It affects all kinds of things. But the court system in which most commercial people will end up is usually a three-tier court system. You have I'll call them by names that are usually used for them, the district court. Then you have the Court of Appeal, if you want to call it this way, but it's called differently. But anyway, Court of Appeal level. And the Supreme Court, Mahkamah Agung, which is a court of cassation, right? It's a French system of court. So basically there's three levels of courts. They're not known to be very familiar with commercial matters. A lot of the business people don't really want to go to court because the judges, unlike in the common law system, many of the judges would have practiced commercial law for many, many years and are appointed in their 50s to become a judge. Indonesia is a civil law jurisdiction in many ways, which means that you become a judge after law school.
Wow.
You go to magistrate school, and well, that happens sometimes in Singapore, right?
Yes,
With
that's right.
very bright people, but in Indonesia it's systematic. So career judges are not trained in commercial law, right? Doesn't in other legal systems for some reason it works out over time, but in Indonesia, there's not necessarily entirely their fault because most business people will go to arbitration, so they also don't have the experience because not many cases go to them. But they are known to have had many decisions that are not so good and not very well reasoned, which is another difficulty. And the process can be quite long. The court, it's a huge country, right? It's not Singapore.
Yes,
It's a
it is
huge
huge.
country. Yes, it's huge. And the Supreme Court has cases from all over Indonesia, thousands and thousands and thousands of cases, because there's a right of appeal to the Supreme Court. So any case can end up in the Supreme Court. So it's a very long process. They're very delayed process. Now, the profession, talking of institution, you have to understand this is a civil law jurisdiction, so you've got advocates and you've got notaries. And the profession, it's a bit like barristers and solicitors in England. It's two parts of the profession, but they do different things. The notaries will be in charge. Most of the commercial counsel will deal with notaries with respect to incorporation of companies. You've got to be a notarial deed for that. Land transaction also has to be in front of a notary. But for most things, for example, going to court, but also advice, etc., you go to advocates for that, right? So you have to know a little bit who you're going to approach if you need advice on Indonesian law, right? Because the profession is separate in two. Yeah, I think that's there's also a commercial court, but you have to be careful. Commercial court has specific jurisdiction. You can't go to commercial court directly on any contract, for example. Commercial court jurisdiction has bankruptcy, for example.
Bankruptcy, okay.
Intellectual property. So there's a few things that are given to that court, which is supposed to be better trained and better at commercial matters. But only those specific things can go to this commercial court.
Okay. Thank you so much for sharing with us the legal institutions in Indonesia. We understand there's a constitutional court, but I think for the purposes of in-house counsel, they probably would not, ever go to that court for work. I think, it's something that they can probably drop off on their minds. I think there is also the commercial court that you mentioned, and I think maybe this is something that they might take interest in if they were to go to Indonesia. But I think for all intents and purposes, I think most in-house counsel would instruct a local lawyer to help them with navigate through the court system. Thank you so much, Professor Bell, for joining us on Regional Counsel. If you have found this episode helpful, please check out the other episodes. This has been Regional Counsel, a production by the Singapore Academy of Law.